Good day, ladies and gentlemen. Joy Stephen from the Palestinian Studios, and here is another Student Herald case law, Juma versus Canada. Case law is not meant for people interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog reportersreport.com as a PDF document. This is an immigration case law and includes topics like refugee status, requirements. Refugee claimant was Palestinian Muslim who alleged that he was unable to return to his home in occupied territories because he had well-founded fears of risk based on his nationality and political opinion. Claimant came to United States in 2005 on study permit or a student visa and remained in United States illegally until 2012. Claimant came to Canada in 2012 and made a refugee claim. Board found claimant lacked credibility and drew negative influence from his failure to make refugee claim in the United States between September 2005 and May 2012. Board concluded that claimant was not person in need of protection because his removal to Israel and occupied territories would not subject him personally to risk to life or risk of cruel and unusual treatment or punishment or torture. With respect to claimant's allegations that his 10-year absence from occupied territories would cause both Israeli and Palestinian authorities to think that he was associated with hostile groups. Board found that claimant's fears were general in nature and any risk he might face would not be personalized. Board also held that claimant's ability to renew his Palestinian passport demonstrated that Palestinian authorities likely did not suspect him of posing a threat. Otherwise, they would not have reissued document that would permit him to return to the occupied territories. Claimant applied for judicial review and application was dismissed. It was reasonable for board to draw negative inference from delay in seeking refugee status and to conclude that claimants lacked subjective fear of persecution. It was open to board to draw negative inference from inconsistencies in claimant's PIF and his inability to provide supporting documentation with respect to certain aspects of his claim. As required by R11 of Refugee Protection Division Rules of Canada, it was reasonable for board to conclude that risk he faced was generalized in nature. Even if one accepted existence of higher risk for those with claimant's profile, risks may still be generalized when it is faced by particular subgroup with greater frequency. There was no merit to claimant's allegations that board did not respect principles of natural justice because it relied on specialized knowledge to reach its conclusion that he was not person of interest to Palestinian authorities, given that he was able to renew his passport without incident. Board's conclusion in this regard were based on evidence before it, and it did not rely on specialized or personal knowledge of extrinsic evidence without notice. Accordingly, S1701 of Immigration and Refugee Protection Act of Canada had no relevance and principles of procedural fairness were properly observed. Another interesting case, Juma versus Canada. The judgment is there in my blog as a PDF document. It's dated July the 9th, 2015 from the Federal Court. Thank you.